Get ready for legal dictation. Article 14 and 226. Writ jurisdiction, res judicata, pensionary benefit. Option: the claim to pension is restricted by the respondents on the ground that the petitioner would have superannuated if he had continued in service on 30/4 1998, and the pension rules requires an option to be exercised before a particular date, which was not done by him. Held that in a situation where the petitioner had been fended off from service and he was litigating before court, unless the respondent had been allowed to exercise the option, the question of the petitioner given up his right to claim pension does not arise. No fault found with the petitioner is not exercising option for pension during the time when the litigation was in progress before the Honorable Supreme Court. The petitioner has already exercised his option for pension on 1st January 2007, and he had also deposited rupees 24,000, being the amount withdrawn by him towards the contributory provident fund. The time prescribed under the pension rule shall be, under the special circumstances, taken as extended till the date when he actually gave a pension, exercising his option for the payment of pension. The petitioner shall be gave a deemed to be admitted into pension scheme, and the arrears of pension shall be calculated and also released with interest at 7.5% per annum. The petitioner is also entitled to arrears of gratitude work out on the scales which he was entitled to in the manner that have been assessed through the order. Narendra Mohan Arya versus United India Insurance Company Limited and another 2012 bracketed for RSJ 465 Punjab and Haryana. Article 14 and 226. Writ jurisdiction, res judicata. The Honorable Supreme Court earlier ordered that the petitioner was entitled to 50% of his back wages. The order to be understood to mean that he should be treated as having a right to obtain every benefit attached to a post, and that would include every annual increments which he would have normally earned. This is to include every revision of scale that was normally admissible to the particular employment which the petitioner held. However, an assumption of a deed promotion on merit consideration may not be possible, but every other benefit attached to the post shall be taken as available to him, since the Honorable Supreme Court had clearly held that the termination of service against the petitioner was justified and found the petitioner's entitlement for reinstatement. The petitioner had already suffered to the extent of not merely